Hi guys, welcome back. It's another Wednesday Wisdom with immigration attorney Pegah Rahgozar. A little bit about our law firm. Our principal office is in Houston, Texas, but we do take cases all across the U.S. and outside the U.S. advising on U.S. immigration laws. Our office phone number is 832-792-3636, and you can learn more about this topic as well as other topics and more about me on our website at www.rahgozarlaw.com. So today's Wednesday Wisdom is a little special for me. Tomorrow is actually my birthday, so that's why today's episode is a birthday edition where I've taken questions from you guys that have already sent them in. Which I'll go ahead and discuss, and I'll also take questions live as people are joining in. But before I get started, as usual, I'd like to let you know that any information discussed in today's video is for informational purposes only and should not be construed as legal advice. Because immigration is a fact-intensive area of the law, it's best that you seek proper legal advice from an experienced immigration attorney before filing anything with immigration. So let's get started. As I mentioned, several of you guys have already sent in questions. Some are basic questions, some are a little bit more detailed, but I'll go ahead and get started with the ones that have already come in. And as you guys join us, feel free to put your questions in and I'll get to them as soon as I can. So one of our viewers sent in a question and they were asking, well, not just one of them, but many of them do ask us questions about where they can get updated information about their case or how long the processing times are for their case. Well, each case is going to be different depending on what type of case you filed, what location you filed. If an interview is required, then it's going to go down to your local office, and that itself is going to have separate processing times. So the best starting point is going to be visiting USCIS's website, and you can do this by Googling USCIS case processing times. Once the website pulls up, it will have two options for you to place in the form number that you filed and the location it was filed at. That'll give you then a general processing time, a window of basically processing time for that application that is currently taking. And so you can kind of compare that to your receipt notice and see if you're within the processing times. If an interview is required, then are you approaching that interview time, so on and so forth. Another useful tool where you can get case status updates is by looking up USCIS's case status. So if you've already filed an immigration case, you can take the receipt notice that you received, input that receipt notice number into the USCIS case status, and receive the latest update. It also does allow you to subscribe to it to receive the latest update. So that's usually the two starting places that you can find out about processing times or what your particular case is looking like with the updates and things like that. You're also able to call the 1-800-USCIS number for similar information from a live agent who will ask you some basic questions. If you have a receipt number, so on and so forth, they can take that and give you processing times or the latest on your case. Another question that came in, so an individual was actually, they actually received their conditional resident card. Conditional resident card is actually same thing as a permanent resident card, except it's issued for 2 years. Those who are married under 2 years receive the conditional resident card. And so this individual had mentioned that their card was issued in error. The date that they actually issued it was 1 year ahead, meaning that they were already approaching the requirement to file. Instead of May 15, 2019, they're putting, May 15, 2017. And so you're like, oh, I'm within the window to file to remove the conditions of my green card. Well, if your case was actually approved today, not 2 years ago, then you still haven't reached that 2-year mark to be able to remove the conditions. So even if that card's issued in error, it still doesn't change the fact that you're not eligible to currently remove your the conditions on your green card. To correct that error, so you don't want to file something that you're not yet eligible for, but you do need to correct the error on your green card. I mean, you can, it's optional because technically by the time you're ready to remove the conditions, you could just have that card with error, but you're timely still filing it when it's appropriate. But if you're kind of paranoid about that and you want to, get the updated green card that has the correct information, well, you can do so by filing the form I-90. If it's a government error, then likely there won't be a filing fee for it. If it was the issue, a card issue because USCIS messed that up, then likely you're not going to have to pay a filing fee for that. However, it's for any other reasons that you need to correct the error on your green card, then likely you're going to have to pay the filing fee. Another question that came up was, can a parent obtain any status by having a U.S. born child? And the answer is technically no. So if somebody comes over here from abroad and ends up, whether they're pregnant then or ends up having a child in the U.S., even if the child is U.S. born, the parents do not derive any sort of automatic citizenship just because their child was a U.S. citizen, a U.S. born citizen. So in that situation, no. However, when the child does grow up and becomes 21 years of age, sure, that child can now petition for their parents to obtain a permanent residency and then later on to become a U.S. citizen, of course, if they are eligible for it. Kind of a similar situation, but with property. I've had individuals ask me, if I purchase property in the U.S. or invest in the U.S., am I guaranteed some sort of status? And the answer is going to be, on its face, no. So buying a house, even if it's an expensive one, you cannot obtain some sort of immigration status or benefit from it. On the business side, if you invest into a business or you start up a business, assuming you're not violating the status that you're on, if you're on a tourist visa for some reason, there's no unauthorized work or anything like that, there may be a way to possibly obtain, employment authorization or an investment type visa for that business. But the fact that you established a business or have property here does not guarantee any sort of immigration benefit or status. I had another individual who asked, they're a U.S. citizen and they want to apply or they have already applied for their parents who are in Iran. So as many of you guys know, Iran is still subject to the travel ban. And as such, even if you petition for whether it's your parents or your spouse or children who qualify, even if you petition for them and USCIS approves that family-based petition, it still has to go through the consular processing phase. And what that means is by the time you go to the U.S. consulate for the interview for your parent, for your child, or your spouse, then at that point the officer, within their discretion and under the travel ban, will likely put their case on hold or likely into an administrative processing, where that could last, several weeks, several months, even several years. And it is at their discretion because of the president's proclamation for the travel ban on Iran as one of the countries listed, then that likely is going to be the case. So we don't necessarily have any particular information on how quickly they're processing these. We've had many cases still on hold after several months, several years, still waiting to see if they qualify for a waiver or if their case will be taken out of administrative processing. So everything could go well up front, getting the family-based petition approved. However, by the time you go to the interview, your case will still be pending. We're seeing very limited number of these cases being granted on waiver and getting their visas issued. And these are going to be for your immigrant visas, so family-based green card petitions. So for those countries under the travel ban, again for Iran for instance, individuals can still apply for a tourist visa or an F or a J or an M visa. Those are the vocational or foreign exchange students or for student visas. Those are still, individuals are still eligible to apply for those. Those are not subject to the travel ban. Another question was about DACA recipients, and this one actually is not really relevant to immigration. This individual asked if they could apply to become a notary or get like a car dealer's license. And because those are going to relate back to either your local or your state laws, that's not necessarily an immigration question. So you're going to have to go with that agency who can best advise you on what type of status you can have to qualify for that license or that notary and so on and so forth. So even if you're a DACA individual, I can't tell yes or no if you qualify for certain licensing or not. That's something you're going to have to take up with whether it's the state attorney general's office for notaries or car dealers, whatever the local or state laws are on that to obtain that license. Still on the focus of DACA recipients, they are still able, if you already hold a DACA work permit, you're able to renew those still. So you can continue to renew those. They are not accepting first-time applications, but they do accept renewals, even if it's outside the 180 days of applying for one. I wanted to kind of discuss a little bit about possible scenarios that happen whenever you're entering the U.S. I recently had a consult with an individual whose visa was revoked when she was entering the U.S., and this happened just recently, and we were discussing this. It was a very unfortunate situation. But this individual was traveling from one of the, was from an Asian country, and she had recently come to the U.S. several months back on a tourist visa, and apparently there was some unauthorized work that she did. And then on her next visit, which was recent, she was questioned, and based on her answers, of course, flagged, and then her visa was revoked with prejudice, and she was sent back immediately, subject to an expedited removal. So a couple things. If you are stopped at customs, questioned, and then sent back, leaving the U.S., you're not even allowed onto U.S. soil after having a dialogue with customs, and they revoke your visa, they're likely going to, first of all, give you a copy of the questions and answers under oath that they've asked you and you've answered truthfully. They're going to give you a copy of that, and they're also going to give you a notice that your visa has been revoked and you're subject to an expedited removal. The expedited removal carries a 5-year ban. It's a 5-year penalty of returning to the U.S. on any type of visa or immigrant visa or work permit or anything like that. So you are subject to the 5 years unless you obtain a waiver. And so this individual, in her situation, in her scenario, she had come in, like I said, did some unauthorized work. Upon questioning, they actually will ask you very normal questions like, what did you do on your last visit? And they'll kind of, it's a very nonchalant, casual conversation that unfortunately will elicit information that could hurt your case. And in her situation, they just kind of casually asked her, hey, what did you do on your last visit? Where did you work? And she volunteered the information about where she worked, and that's where they found out she did in fact violate the status of her tourist visa, the terms of her tourist visa. Because when you're coming here on a tourist visa, you're here for travel or business purposes. However, with business purposes, you're still not working, quote unquote, and you're not also receiving compensation for it. So even if you're here for business purposes, you can attend a conference, you can negotiate contracts, you can, purchase a lease, or enter into negotiations or attend a training or something like that, but you just can't work and be paid for it. You can be a volunteer, you just can't be working. So a couple of tips that I would like to share, because I see this time and time again with individuals, like I said, that enter on tourist visas. They have no idea, the basics of what it means to be on a tourist visa, and then they end up violating the terms or flagging themselves for customs to revoke their visas, and then now they've got this ban. So a couple things that generally do come up with customs that they ask you are, what is the purpose of your trip? So you want to be very cautious and very prepared to answer this appropriately. You don't want to lie, of course. You don't want to make up anything, and you don't want to sound nervous like you are lying about something. So be ready with a concise answer. What are your reasons for visiting? Are you here to just enjoy vacationing here? Are you here to see family members? Are you here to attend a conference? Whatever the reasons are, as long as they're not violating the terms of your visa, be very forthcoming with your response for the purpose of your visit. They will also ask you how long you intend to stay in the U.S. and where. And this is kind of one of those catch-22. You got to be very careful because most lengthy travel stays in the U.S. are going to raise flags. So a normal person who's got a job abroad and is vacationing, they're probably vacationing for a couple of weeks and maybe like a month, unless they're like a teacher or something. Maybe they got the whole summer off, so they got 2 or 3 months. But a normal individual with job, employment abroad is not likely going to stay a full 6 months. So that right there is already going to be a flag if you're planning to stay the entire time that you're allowed your duration of stay in the U.S. for your I-94. Even if they stamp you for 6 months, you know, you shouldn't be planning to stay a full 6 months. Also, you know, where you intend to stay. Are you staying at a hotel? Are you staying with family, your friends, at a hostel, at an Airbnb? Be prepared to have that information, you know, the address, the information of the person's name if you're staying with somebody, you know, all that ready to go. Even if you carry a travel itinerary with you, you know, or you're booking reservations and things like that for your hotel, or, you know, like I said, information about your relative that you're planning to stay. These are things that are going to flag you if you're not ready to promptly respond. And also, even with the terms of where you're staying or where you're what you're planning to attend, like if it's a conference or whatnot, they will go back and look that up if they suspect you may be lying. And again, some of these things may flag you when you're coming in from a certain country. You know, certain countries in Africa get flagged, certain Asian countries get flagged. These are things that you want to be mindful that you might already be on the radar of customs as someone that they would like to question because of typical fraud from those countries. Or, you know, or if they've, you know, already been alerted in the past that these are individuals that likely come in and overstay their visa or come in and work on their visas. So be mindful of the country that you're coming from, and that might raise flags as to more line of questioning. Also, again, if they ask you a series of questions and you're not prepared to answer them, or you're lying about it and they go back and search it, and, you know, those things can definitely raise suspicion. And if they do have suspicion, of course, they'll take you into secondary inspection. At that point, you're not entitled to an attorney, of course. They could sit you down for several hours, go through your belongings, especially your cell phone or your laptop. And if you have any sort of incriminating type information, such as, you know, you're making plans for a job here in the U.S. that you're planning to work as soon as like they might ask you what's your occupation. And that actually is very important because it goes to two things. One, are you financially able to support yourself during your stay in the U.S., or are you going to become a burden on the U.S., right? So that's important about your employment. So they will ask you that. That actually will also go to whether you plan to stay in the U.S., right? Because if you're unemployed abroad, you just quit your job and now you're coming to the U.S. to vacation, well, that likely can raise a flag to U.S. Customs, and they could wonder, well, are you now here to look for employment in the U.S.? Do you already have a job offer in the U.S. and you're planning to come work in the U.S. on a tourist visa? Things like that. So be very careful about your employment abroad, whether you're working, you recently quit, things like that. They also ask you the places you plan to visit and the names of those places. So be prepared to have a list of all that information. Again, if they're not satisfied with the line of questioning because your answers just do not match up, or they seem like they might be flagged for someone who might overstay or violate the terms of their visa, they can issue you the expedited removal. It's very difficult to really have any constitutional rights to fight an expedited removal, especially if you're already in customs at a port of entry when you're entering in through an airport, for instance. It's a little different through a land port, but generally with customs, when you're arriving at the airport, they're a lot more strict. They could literally put you back on the next flight back home. A couple things to be mindful though, when you're entering, and let's say you know, you do raise suspicion to them and they want to send you back to your home country and revoke your visa. They will ask you if you have a fear of returning to your home country. And if you really do have a legitimate fear of returning because you may face persecution, torture, imprisonment, or death at the hands of either the government or someone the government's unable or unwilling to protect you from, then at that point you want to let the government know, you want to let customs know that you are in fact afraid to return to your home country. So at that point, that's kind of like your last shot at keeping yourself in the U.S. before they send you back through expedited removal, is by claiming fear of return. Now, I would not recommend this if you generally don't have a fear. Like if you're okay going back home, then don't make up a story and say you're afraid. But this is really for those who do have a fear of returning. And at that point, then what they'll do is take you into custody and then they may later on release you, but then you'll go through what's called a credible fear interview process. If this is your first ever entry and you've never been previously removed from the US, then they'll put you through the credible fear interview process. You're able to talk to an asylum officer about your fear, and if they feel like it's a legitimate claim, then they'll refer you to immigration court, and then you can present your full case in front of an immigration judge. If you get a denial of that credible fear interview, you'll still have a chance if you decide to go before an immigration judge who will rehear the claim, and if they feel like it's a strong enough claim, they'll set it for an actual hearing. If not, they'll pretty much agree with what the asylum officer said. But that's all kind of separate. I won't really get too into the credible fear. There's another route too, that's the reasonable fear interview. That's really for people who have already been deported once. They're returning a second time, and now they're claiming fear. It's a higher burden to me, but again, I won't really discuss that in this video. I had, general questions that also come up is, how can you legally come to the US? Well, that's kind of a broad question. There's no specific path, and not everybody qualifies for every single option that's out there. Most common ones, of course, are going to be your family-based cases. Then you have the employment-based cases, whether it's a visa for work or a green card through your work, or there's investment route. Now, some of these may not be applied to you. You may not be eligible for it, or you might not meet the requirements to obtain that. So it really comes down to a case-by-case basis. Things that factor in are, again, ties to the US, who's a family member who's applying, or who's the employer that's applying, what's your credentials, what's your background, what amount of money do you have. Things like that are going to factor into the types of questions that we'd like to discuss with you to then figure out what your options are, if any. Not everybody's going to qualify, like I said. The bare minimum that maybe people can qualify for are going to be your tourist visas. But again, with a tourist visa, though, you'd still have to show ties to your home country. So that's its own dilemma. So we do have some questions here. Under what circumstances applying for U.S. citizenship by a green card holder can result, can result in deport orders? Under what circumstances applying for U.S. citizenship by a green card holder can result in deport? I mean, that's kind of a vague question, unfortunately. However, let's say, I'm not sure about what you mean is exactly by a green card holder applying for U.S. citizenship, but I'll kind of generally address ways that you can be placed into deportation, and hopefully that addresses your question. But basically, the general ways you can be put into deportation as a permanent resident, as a green card holder, are if you've committed a crime that's a deportable crime, you can be placed into deportation. If you have any sort of false claim to U.S. citizenship, let's say you registered to vote, or you voted, or on an I-9 application for employment, you put that you're a U.S. citizen, and then later on you're flagged, that's a deportable offense. If you make any claims of fraud or misrepresentation to obtain your green card, those are all deportable offenses. And even if you initially obtained your green card, later when you go to apply for U.S. citizenship, these things will come back to haunt you. What you want to realize is that from the first day ever that you ever apply for any immigration benefit, be that outside the U.S. or inside the U.S., whether you're applying for a tourist visa, or you're applying for a family-based green card in or outside the U.S., you're applying for asylum, I mean, whatever it is, be mindful that your immigration file will stay with you up until you become a U.S. citizen, a U.S. naturalized citizen. So any detail that you've left out intentionally, or you lied, initially, and then later on down the line you changed it, any discrepancies in the information you provide, in your biographical information, in your marital status, in having children, in your address history, I mean, all of these things, you got to be mindful that each application, from one application to the next, you want to have consistent information. So obviously we advise you make copies and keep copies throughout your entire immigration history, so you can always compare, and if there is an issue, then you address it, but you don't want to ever hide anything. So anyways, I hope that answers your question, or at least kind of helps clarify. Along the notes of that, actually, I did have someone else ask me this person obtained asylum status first, then applied for permanent residency, and then once they obtained their green card, now they're wanting to travel abroad back to their home country. Well, if your home country is the country you claimed fear of persecution, and that's how you obtained your asylum status initially, then you can by no means return to that country, because now you're going to avail yourself to that government or to the group that you're fleeing from, right? And that could raise all sorts of issues, such as whether your initial fear was credible. Did you lie to obtain your asylum status? Or did you have a legitimate fear? I mean, these are things that are going to come up later on. Even if you get lucky and let's say you have your green card now and you've traveled back home, right? Well, two things can happen. When you're re-entering the US, customs can give you a hard time about where you went to travel, how long, and all that. Well, on your green card, it's going to tell you the category that you obtained your green card. And if it's listed as a category under asylum and you're returning now to the home country of persecution, that's going to raise flags. They're going to wonder, why did you return to the country that you claimed fear? And if they are not satisfied for your reasons, they can initiate removal proceedings against you and put you into deportation. And now you're going to have to face an immigration judge and explain why it is that you returned to the country that you supposedly claimed fear. Now, let's say you're a lucky one and you travel back home safely and you came into the US, customs didn't give you any problems, right? Well, now it's time for you to apply for citizenship. And you're like, okay, no big deal. I've crossed, everything's good. Everything looks good. No issues. Well, that's the last step that the government can get you. And so if you have lied or if you have these travels that can raise flags, that will come up during your citizenship and during your citizenship interview. And if you do have something that basically violates the terms of your green card, that will raise flags. And they could either deny the application for citizenship, or they could deny it and then place you into removal proceedings. And again, once again, if the denial is based on you were an asylum seeker who obtained a green card and then applied for citizenship and then you return to your home country, well, now that's an individual that's going to have to explain to the immigration judge why it is that they returned. And remember, anytime you're in immigration court, this is an uphill battle. I mean, it's always easier and smoother process if you can hopefully hire an attorney, but also if you're dealing with USCIS. That's the benefits branch. Those are the ones that, it's a lot easygoing. I mean, it's a less hostile environment, things like that. Once you're in immigration court, the burden's on you to prove why you're not a deportable individual, right? And so you're now in front of a judge. You've got the government attorney as the opposing side. You have to go through all this, obtaining evidence and witnesses and go to trial. I mean, it can be very nerve-wracking, and it could take for years to obtain, a decision, good or bad, and then you want to appeal it and so on and so forth. So again, why go through the headache when you can seek proper legal advice, hopefully follow that legal advice, and avoid all this headache? So it seems like that's pretty much the Q&A that we have for today. I hope it's been useful to you guys. I'm glad you're here to basically celebrate my birthday with me and engage in some dialogue about the basics of immigration law. I do enjoy these sessions every week with you guys, and I'm grateful to have you guys tune in every week on Wednesday to listen to me, and I'm grateful for that. So I look forward to speaking with you guys again next week for another episode of Wednesday Wisdom with Pegah. If you do have any questions, anything particular about your own case, then please call our office at 832-792-3636 so we can discuss your case. Thank you so much for everybody sending me shout outs on my birthday. Happy birthday to me. Thank you so much. I really appreciate it. And I'm glad I got to enjoy this evening with you guys. Take care. I'll see you guys next week. Bye-bye.